Welcome to Legal Skill channel. If you are new to channel, kindly subscribe the channel, like the video and comment below about the video. You can purchase the course made by me from Udemy. The name of the courses are shown on your screen. Let me read it for you. Learn drafting commercial contract, legal research using Google for lawyer law student, Adobe Acrobat Pro DC for lawyer law student. So in this video, I have explained about basic of drafting commercial contract, which is a part of Learn Drafting Commercial Contract course. You can purchase the course from Udemy if you like the video along with all the reading material. Please note that Learn Drafting Commercial Contract is the cheapest course on the internet. It will cost less than 1000 rupee or less than $10. Buying contract courses from other website will cost you more than 10,000 and it will go up to lakh. So by purchasing this course from Udemy, you will get all the video content along with reading material. Let's start. Drafting cover page. Nowadays, there is growing trend of adding cover page in an agreement. The cover page should include title of the agreement, date of the agreement, full official name of the parties. Don't write definition or address of the parties on the cover page. Otherwise, the brevity and neatness of the cover page is lost. The cover page should consist of one page only. In case of too many parties to an agreement and their names cannot be accommodated in a single page, then you can do away with the cover page or just write the name of the agreement on the cover page. Please note that some of the legal firm put their name and logo on the cover page. A sample of cover page is shown on your screen for your convenience. Title of the agreement. The title should clearly state the nature of the business or transaction the parties intended to undertake under the agreement. The title of the agreement should be specific. Simply mentioning the agreement does not work. In layman terms, most people call any sort of commercial arrangement as a partnership, but you should be specific while drafting your contract. You have to check whether the partnership is agency or joint venture or something else. Then you have to give suitable title to the agreement. Before you give title to the agreement, you have to see the nature of the transaction. In some cases, there are several transactions under same agreement. Then you have to write two important aspects of the title. Look at the screen to see this example. If the parties entering into a joint venture agreement, along with the parties also enlist their right and obligation as a shareholder of the joint venture, then you can give the title as joint venture and shareholder agreement. Interpretation of agreement. Please note that the court, while interpreting an agreement, always goes through the content of the agreement. The title of the document is a misnomer. Drafting different version of the agreement. Draft of an agreement is reviewed by many parties and their professional. They suggest several changes as per their interest. Because of this, different version of the draft is made. Hence, it is advisable to mark the draft so that no confusion occur while discussing the draft. Therefore, before you circulate a draft, mark it at the top of the draft. Look at the screen to see how different version of the draft is marked. For the first time, you can mark it as preliminary draft for discussion 12 January 2019/XYZ Associate. After receiving input from the parties, you can mark second draft as revised draft 15 January 2019/XYZ Associate. In case of several rounds of discussion and the draft is amended frequently by the parties, then you can mark the draft as revised draft 15 January 2019/XYZ Associate version 2. Similarly, you can also write revised draft 17 January 2019/XYZ Associate version 3. Revised draft 19 January 2019 XYZ Associate version 4. Revised draft 21 January 2019/XYZ Associate version 5 and so on. Drafting preamble. The first sentence of an agreement is called preamble.
The preamble include title of the agreement, abbreviation of the title of the agreement if any, date of execution, and place of execution. A sample of preamble is shown on your screen for your convenience. There can be some variation in the preamble of an agreement as per the need of the agreement, and same is discussed in the upcoming chapters. Execution place. The place of execution is mentioned in the preamble of the agreement. In case the parties to the agreement is located in the same city, then the format of the preamble will look like as shown with green color. In case of the parties executing the agreement is located at different city, then you must delete the word at from the above quoted text, which is highlighted with red color via circle. Now the preamble will look like as shown with pink color. In case the parties to the agreement is at different city, then each party must indicate the place of their respective place at the signing page, not in the preamble. The signing page is the last page of the agreement where the parties to the agreement sign the contract. So the format at the signing page will look like as shown on your screen. Execution date. The execution date is mentioned in the preamble of the agreement. Look at your screen. The preamble of the agreement is highlighted with pink color and the column for the execution date is circled with red color. It is very important to mention the date of execution on the agreement as well as the date from which the agreement becomes operative. This helps in asserting the parties their respective right. Relevance of mentioning execution date. As per section 23 of Registration Act, it is mandated to register the document within 4 months from the date of execution of the agreement for the registration of the document. Look at some of the ways in which you can mention the execution date. In case the parties to the agreement is signing the agreement on the same date, then you can write the date of execution in the preamble of the agreement. The example is highlighted with pink color. Look at your screen. In case the parties to the agreement is signing the agreement at different date, then you can write the date of the execution at the signing page. Now what is signing page? Signing page is the last page of the agreement where the parties to the agreement sign the agreement. It is also called execution page. The format to write the date of execution on the signing page is shown on your screen. In case the parties to the agreement are executing at different place and on different date, then you can write the place of execution and the date of execution at the signing page. The format to write the place of execution and date of execution is shown on your screen. Please note that to avoid any kind of manipulation, the date should be written in number and words. Let's see this example. In this example, the parties are signing the agreement on the same date. The example is highlighted with pink color on your screen. Description of the parties. Description and authentication of the parties before writing an agreement is very important. The description of the parties should be enough to identify them in case of dispute between the parties. Nowadays, the government authority in various departments asks for photograph, social security number, thumb impression of the parties on the spot so that impersonation is checked. Relevance of self-certified copy. When you register some document under any act, then retain self-certified copy of the document. It is very useful for future reference. Description and authentication in case of a person. Give complete name matching with the official identification document of the government. Don't give abbreviation or nickname. Father's name for males. Father's or spouse name for females only. For address, give passport, utility bill, election commission card, Aadhaar card. You can also give other document like permanent account number, GST registration number, passport, Aadhaar card, director identification number in case of company, bank account number for processing any kind of payment under the agreement, especially in the operative clause. You can give any other ID prescribed by the government. Please note that the passport number changes on renewal. Minor. Minor will always act through the natural guardian appointed either through the court or through some instrument. In such a case, the description of the parties will be written in the agreement as shown on your screen with pink color. Trust. In case of trust acting through some person, you have to write a line in the agreement as shown on your screen with pink color. Such line will signify who is the trustee. Power of attorney. In case of power of attorney, if the power of attorney holder is entering into agreement, then a line on behalf of power of attorney holder should be written in the agreement. And also a copy of power of attorney should be attached with the agreement. A line highlighted with pink color is shown on your screen. You can write a similar line in your agreement. Description and authentication in case of a corporate entity. Name of the entity, registered office, corporate official postal address, email ID, bank account number for processing any payment under the agreement, especially in the operative clause. You can also give other document like permanent account number, corporate identification number for companies and LLPs, registration number for firms, GST registration number. You can give any other ID prescribed by the government. Please note that the PAN, CIN and tax registration number of the corporate entity is permanent. Other detail may change like name and address. Numbering of parties. Numbering of parties in an agreement is very important. It is very easy to number when there are only two parties in the agreement. Be consistent with the nomenclature. When you define a party by its status, let it be as tenant and landlord. Then throughout the agreement write tenant and landlord. Adding the before the word like the tenant and the landlord would be inappropriate. Similarly, you can define the status as the tenant and the landlord. Removing the from the word and writing as a tenant and landlord would be inappropriate. Be consistent with the formatting. More than two parties. Earlier, if in the agreement there are more than two parties, then you have put number to their respective name to indicate their position. For example, let's look at the screen. The example is highlighted with pink color. You can see at the end of the Mr. KLM, the first part, and at the end of Mr. OPQ, second part, and the end of Mr. XYZ, third part is written. Now there is problem with this method. Let's see the problem. Problem while drafting in above stated manner. The reader cannot be expected to know the number of each party. He has to flip the pages again and again while reading to know the obligation on each party. In some cases, some of the parties ceases to be the party to the agreement. Then the agreement would be misleading. Now the best option is to execute fresh agreement or amend the agreement wherever is necessary. New ways of drafting where there are more than two parties. The parties to the agreement must be defined their respective name, status, and role under the agreement. Example, employer, employee, contractor, agent, and so on. Exception to this rule. Other than partnership cooperation agreement where the status, right, and obligation of the parties are different from each other in the agreement. For example, in case of joint venture between two parties, the first and the second party The first and the second party must be defined by their respective name, and the third party must be defined by the joint venture or JVC. In case where the parties to agreement have the same status like buyer, employer, then individually the parties must be defined by their respective name and collectively as their respective holder like parties. For example, the owner and the contractor are hereinafter jointly referred to as parties and individually as a party. Abbreviated names. It is better to assign the parties the abbreviated name because the writing full name throughout the agreement is hectic and cumbersome. But be consistent with the abbreviated name throughout the agreement. You can see the example is highlighted on your screen with pink color. Mr. XYZ has been abbreviated as the lessor, and KLM India Private Limited will be abbreviated as the lessee. From now onward, Mr. XYZ will be represented as the lessor and KLM India Private will be represented as the lessee throughout the agreement.
Whereas clause or recital clause. Recital clause is basically a story behind the agreement. It tells us from the introduction of the parties in the agreement, their relationship to each other to the execution of the agreement or contract. Recital is also known by other names like introduction, background clause, or whereas clause. Recital clause is introduced after the title of the agreement and description of the parties. Now let's see the recital clause in sale of property. Whereas the vendor is the sole and absolute owner and in possession of one built shop at ground floor area measurement 8 feet 6 inch into 23 feet, that is about 18 square meter, without roof right up to ceiling level only, fitted with electricity connection and with separate meter running condition, and one iron shutter. Part of the property bearing number 49 out of Khasra number 51/80, situated in the area of village Haus Khas, Abadi of West Guru Anand Nagar, Saket Ilaka, South Delhi 17, along with the proportionate, undivided, indivisible, and imparcelable ownership right in the land underneath, with all its freehold right, title, and interest of the said property. Now let's talk about the boundary of the said property. So in east, the property of father, again west, the property of father, in north, the Gurdwara Road, and south, the senior secondary school. Having purchased the above mentioned property by vendor from Srimati Geeta Devi, wife of Sri Satya Devi, via sale deed duly registered as a document number 5680, additional book number 1, volume number 910, page number 38 to 43, dated 1 November 2016, with the office of Sub Registrar 8A, Delhi. And whereas on the basis and strength of the fact and document aforesaid, the vendor has represented that she is the sole, absolute, exclusive, and rightful owner and in possession of the above property along with the freehold and underneath all fitting and fixture, and vendor has got full power, absolute authority, and unrestricted right, and is fully competent to sell or dispose of the above mentioned property either in part or in whole to anyone in any manner as she may like, or and same is free from all sort of encumbrance, and there is no legal defect in the title of the vendor. And whereas the aforesaid above colony was regularized by MCD/DDA via resolution number 54 dated 1st February 1983, the property was neither notified nor acquired by government or any public purpose. And whereas the aforesaid property under sale is neither acquired nor any acquisition proceeding have been initiated under the Land Acquisition Act, therefore there is no bar or any legal complicated for transfer of the said property by the vendor to the vendee by way of this present sale deed. And whereas the detail of the previous sale purchase method in the instrument by virtue of which this property belongs to the vendor is accurate and correct. In this regard, if any dispute arise in the future, the registering authority and document writer advocate shall not held be responsible, and the parties
shall bear all the responsibility. And whereas it is declared that no stay on sale or purchase of the said property granted from any competent court of law or any competent authority up to this day, and if any dispute in this regard arise in future, the registering authority or document writer or advocate shall not be held responsible, and the parties shall bear all the responsibility. And whereas the vendor for her bona fide needs and requirement has agreed to sell the said property to the vendee for a total sale consideration amount 10 lakh, and the vendee has also agreed to purchase the same. So in this way you can draft a recital clause in a sale deed. Types of recital clause. So there are two types of recital clause, and the first is narrative clause. Basically it tells the history of the party, their business relation and their previous discussion. The second is introduction clause. It tells us about the reason for making the agreement. Please note that most of the time the two recital clauses are mixed together. They are mixed in a such a way that they cannot be separated. You can also mix these clauses while writing. There is nothing wrong in this. Now let's talk about the element to be included in recital clause. So introduction of the parties, business of the parties, subject matter of the agreement, detail of the offer and acceptance to the agreement, detail of any previous document executed, parties intention. So you need to remember these 6 points while drafting recital clause. Now let's talk about what you will do when the recital clause is lengthy. So you can break down it into a simple paragraph and arrange the paragraph in chronological order. Now let's talk about importance of recital clause. So it provides important story from beginning to the execution of the contract or agreement. It also gives the reason for the need of the agreement. Without recital clause, it is very difficult to understand the agreement. In simple word, it basically explains the common goal of the party. Now let's talk about importance of recital while making sale deed. So it is very important in sale deed, especially in case of immovable property, as it helps in tracing the immovable property itself. The buyer will know the chain of the title of the property, which help in assuring the buyer that the title is good. Precaution. Let's talk about the precaution you need while drafting recital clause. So don't add too much unnecessary information. Avoid repetitive sentences, as there are other clauses in the agreement. Sometimes recital may control the operative clause, so be cautious while drafting. Ways to write recital clause. So let me talk about the first method. So in this method, you will write whereas in the first clause, and in the later clause you will write and whereas. You can see this is the first clause. It started with whereas, and the subsequent clause started with and whereas. You can see this is the second clause, this is the third clause, this is the fourth clause. So using first method, you have to write whereas in the first clause, and in the subsequent clause you have to write and whereas. Now let's talk about second method. So in this method, you will write whereas as a heading, and then number the subsequent clause either numerically or alphabetically. So this is the example. We can see whereas as a heading, and we can see it has been numbered A, B, C, D. So in this way, you can number the subsequent clause as a ABCD or 1, 2, 3, and give whereas as a heading. Now let's talk about third method. So in this method, you will write information, background or introduction as a heading, and thereafter number the subsequent clause either numerically or alphabetically. You can see this is the example, and information is written here as a heading, and we can see the subsequent clause are numbered as A, B, C, D. And so the second and third method are almost similar. So in this way, you can draft recital clause. Now let's talk about no recital. No recital basically means where there is no necessary of recital clause. In loan agreement, there is no need to write recital clause. Basically, the parties are defined as borrower and lender straightforward after the description of the parties. You can mention the money, tenure, and other terms in the operative clause. In other words, you can safely say that recital is not needed in loan agreement.
Effective date. The agreement must indicate effective date. Effective date means when the agreement will come into effect. The agreement comes into effect into three ways. First, simultaneously with execution. Second, with retrospective effect. And third, from date later than the execution date. Let's see the example of each. Example of simultaneous execution. Please note that when the effective date is not written in the agreement, the execution date is assumed to be effective date. Example of retrospective execution. Under contract law, it is not mandatory for the parties to start commercial relation with an agreement. The parties to the commercial relation can make agreements subsequent to the existence of their business. In such a case, the parties can sign an agreement with earlier date. Example of future execution. In case of agreement to sell, the date of execution will be future date. Now let's see probation period. Sometimes in the contract, all the provision of the contract are not effected from the same date as given in the effective date, especially in employment contract. Employment contract often have a probation period in the contract. During the probation period, the term and condition is different than that of the confirmation of the employment. You can see example of probation clause is highlighted on your screen. Let's see some of the examples of effective date. The example is again highlighted on your screen with pink color.
Nomenclature of operative provision. Nomenclature is very important in an agreement. It is used to refer to the operative clause of the agreement. The most frequently used nomenclature are article, section, or clause. You can choose any of the nomenclature, but it should be consistent throughout the agreement. Generally, the British prefer clause, while American prefer article. Overlapping. If you name the operative clause of the commercial agreement as an article and you need to refer to the article of association under company law in the same agreement, then while drafting commercial agreement, you may have to face hardship a little bit. In India, AO is commonly called article. So to avoid hardship, you may name the operative part as a clause. Alternatively, you can keep the name article of the operative clause and write article dash of AOA whenever you need to refer to AOA. Again, if you refer to some section of the act passed by the Indian Parliament and you name the operative clause as a section in the agreement, then it will cause hardship while drafting the agreement. To avoid such hardship, it is better to mention in the definition section or interpretation section of the agreement whether you are referring to a article, clause, or section of the agreement or that of some other act. Proper heading of substantive provision. The heading clause in the contract helps in understanding of the contract clearly. While interpreting the provision of the agreement, parties to the contract often draw the meaning of the provision from the heading of the agreement. But the court, while interpreting the clause, don't give importance to the heading. It gives importance to the provision. You can place the heading of the contract to the left hand side or in the center. Never place the heading on the right hand side. Remember to be consistent with the format of the heading. Under the heading, include the provision of that heading only. If you are unable to get in mind proper heading or unsure about the heading of any provision, then give miscellaneous as a heading and put the provision under it. Numbering scheme of provision. So in this lesson, I will teach you how to number provision or clause in an agreement. Provision or clause basically are same thing. So let's start. So while numbering the provision or clause, be consistent with the format. Don't use A, B, C to number some subclause and then again 1, 2, 3 to number other subclause in Roman, or 1, 2, 3 to again number some other subclause. In case of lengthy agreement, numbering the provision or subclause can be tricky. You cannot number more than 26 provision using English alphabet like A, B, C. In such case, it is much better to number the clause using number. Let's see this example. You can number the clause or provision as 1, 2, 3, 4, subclause as 1.2, 2.1, and you can again further number the subclause as 1.1.1 in this way. So by numbering in this way, you can never confuse while numbering clause or subclause. But remember to keep the number scheme consistent throughout the agreement.
Definition used in agreement. While drafting an agreement, there are several terms used in the agreement, but it is important to define the term which is necessary, which we want to give particular meaning throughout the agreement. So definition is often added to give a word a particular meaning, which may not be same as the dictionary meaning. Now let's talk about purpose of definition. You can abbreviate using definition of lengthy names in the agreement like KLM Construction Company as KLM or ABC Private Company Limited as ABC. Abbreviate lengthy names will make your agreement easy to read and understand. Restrict the meaning. It is used to expand or restrict the meaning of a particular word in an agreement. In other words, you can restrict the meaning of a particular word to that agreement only. Dictionary meaning of the word will not be applicable to the contract. So it is mostly used to restrict or expand the meaning of a particular word in an agreement. Now look at the example. In the payment clause, dollar may signify different meaning to different people. It might be US dollar, Canadian dollar, Australian dollar, etc. So while writing dollar in payment clause, specify the currency you are referring in the agreement. Most of the time, definition is used to serve single purpose, event, document, but it can also be used to serve collection of document, number of people, many event, etc. See this example. Seller can include multiple parties. Document can include multiple document. Event can include several event. It might be past, present, future event. It is necessary to define the party's authority, condition, name of the document as it makes document easy to read and understand. It also makes document easy to interpret. It provides consistency in the agreement by reading the definition section. The reader can be sure of the meaning of the defined term throughout the agreement.
Example: KLM Construction Company can be defined as the company in the definition clause. However, the word the company is used in the agreement, it will mean KLM Construction Company only. Precaution while drafting definition clause. In case the definition clause is drafted improperly, it can cause confusion while reading the agreement. For example, if the word company is defined in the agreement and you are writing the company in the agreement, then in such case it will create confusion whether you are referring to the term company as per definition clause or any other company mentioned in the agreement. In this example, you have seen that if you define the word company, then mention company only in the agreement. Don't mention the company. Otherwise, there will be a confusion about the company which we are talking about. Precaution while drafting means and include. Means and include are not same, they are different. If you are writing means in agreement, it will be restricted to that thing only. And if you are writing include, then it will include other thing also including the given list of item. So writing means and include together in an agreement is confusing and also wrong. You should write either means or include depending upon the circumstances. Means will be used in restrictive sense while include will be used in inclusive sense. Define the only term used in the agreement.
Define the only terms which are going to be used in the agreement. If you are not using the term in the agreement, then don't write it in the definition clause. It often happens when you copy paste from another agreement while drafting agreement, you also copy paste the definition clause. There may be terms which are not used in the agreement and just copied it from another agreement. This also happen in case where there are too many round of discussion and some clauses are deleted before the final round. In all these scenarios, check the definition clause before finalizing the agreement so that there may be no term which are not used in the definition clause. Define the term only when you use the term more than once. Define the term which are used more than once. The reader of the agreement will understand that agreement if any term is appearing only once. Don't define simple term. Don't define simple term understood in common sense. Define the simple term only when it is urgent. Capitalize first letter. The first letter of defined word will always be capital. For example, investor, company, etc. unless you have a strong reason for not doing so. Capitalize all word if several word. If the definition clause consists of several words, then all words should be capitalized except something for joining word like or, and, on, in, of, under, etc. For example, annual general meeting, AGM, Government of India, GOI. GOI can be in capital or O can be in small. Return of investment. You can write ROI all in capital or ROI here O will be in small. So in this way you can capitalize all word if there are several words. Do not define in capital letter unless you are defining something in abbreviated form. No definition should be in capital letter. Capital letter should basically mean you are shouting. For example, XY private company, board of director, etc. However, in case of defined term is in abbreviated form like XYZ private company as XYZ, etc., then capital letter may be used. So you can write XYZ in capital if you have defined XYZ private company in definition clause. Otherwise, don't write in capital. Other references. If any reference is made in the agreement regarding article, section, exhibit, etc., then it will be reference to the article, section, exhibit, etc. of that agreement only. If any reference is made regarding any article, section, exhibit of any other document, then the reference must start with a smaller letter, not capital letter. If you need to make reference to the article, clause, section to any other document, then be specific while giving reference, like Article 305 of Constitution of India, Clause 9 of Technology Transfer Agreement. Define the term at one place only. In commercial agreement, we often tend to define terms at various places like introduction sentence, description of the parties, recital, definition clause, operative clause, annexure. Define the term at one place only so that reader don't have to flip off pages. Defining the term at one place will make the agreement lucid, easy to understand. In case you need to use simple term multiple times in one clause, and also you need to make exception in that clause regarding the same term, then define the term in that clause only so that reader does not have to refer to definition section. Use the defined term only after definition. Don't use the term before definition. Don't say the company as defined in article of association. First define the term the company in the definition clause, then use word the company in operative clause. Stay with the definition. Once you define the term in the agreement, be consistent with the term throughout the agreement. For example, you have defined company as ABC Private Limited Company and board to be the board of director of KLM Private Limited Company. Then write board to refer to board of director of KLM Private Limited Company, not board of director. Similarly, write company to refer ABC Private Limited Company, not the company. Don't use multiple terms for the same party as it will cause confusion. Define another document. If in your agreement you want to refer to another document, then while defining such document, provide adequate detail like name, execution date, parties relating to such agreement, etc. Define alphabetically. While drafting definition clause, define the term alphabetically. Defining the term alphabetically will help you to locate any term easily. Don't add number to the terms as the definition clause often changes. So you have to delete the number or add number or modify number. It is common practice in all sort of agreement not to add any number. Keep your client in mind. Keep your client interest while drafting the clause like defining the confidential information. Always take your client opinion before defining such term in the agreement. Like while defining the term default, even ask your client whether he is likely to be defaulting party. Then define the term to serve the client's best interest. Define well and define only once. The definition clause should be precise so that the reader can easily understand it. Also define the term like person, entity, event only once. Define the parties by their name if there is multiple party, as it will help the reader to understand it easily.
Use capitalized term carefully. If you have defined any term in the agreement like partnership, tenant, then use the term carefully throughout the agreement. The defined word should be used in consonance of the meaning of the word defined in the agreement. For example, you define the company to mean XYZ Private Limited Company in the agreement. Then if you write the company, it will mean XYZ Private Limited Company. Hence, wherever you write the word the company or the company, the first one is in the small and the second one is in the capital. In the agreement, it will mean XYZ Private Limited Company and no other company. Similarly, when you write party, the first word need to be capitalized in the agreement. Then the word party means party who are signatory to the contract and no other party. Wherever you write reference to the third party, you should write as a party, the P should be small and not as a party where the P should be capital. Interpretation. The interpretation clause is different from other clause. It explains the rule of interpretation in the agreement. It does not refer to the interpretation of a defined term alone. An example of interpretation clause is highlighted on your screen with pink color. Please note that through the interpretation clause, you clarify reference to the provision or document only. Otherwise, you have to clarify each time about the provision or document. If you fail to clarify any point, then it will be interpreted against you. Importance of interpretation clause. To avoid the above stated problem, interpretation clause is added in the agreement.